you, Nicole. Okay, this is Nick at Rubicon Real Estate, and the website is rubicon.la. And so, okay, this session we're going to talk about actual notice. This is very important because I'm going to lead from this into the nightmare, and it's all true. The actual notice is conveying facts to a person with the intention to apprise that person of a proceeding which is in her interest. For example, I sue Ben. I have to prove that he's been served. So the marshal comes in, they give you something, you sign for it. Sometimes they even take a picture, okay? Because there was a lot of fraud going on. That would constitute actual service. You got actual notice, okay? Let me see what else it says. As a legal, when such a notice has been given to someone personally, it is called express actual notice. So if I hand it to you, that's express actual notice, okay? If a tenant notifies a landlord that the elevator is broken, the landlord has express actual notice of the defect. I told the landlord this is what happened. Should the landlord fail to repair the elevator, okay, and another tenant is injured while riding it, the landlord would be liable for the tenant's injuries because I told Fred about the problem. I'm going to make him the landlord, okay, and then someone got injured, and that someone injured sues him, and then I become a witness that I, in fact, did tell Fred this, okay? Actual notice can be presumed if an average person having witness of the same evidence should know that a particular fact exists. This is called implied actual notice or implied notice. If the landlord had been with the tenant when the tenant discovered the broken elevator, the landlord would be considered to have implied notice of the fact. So I said to Fred, the elevator's not working. That's implied. But the point is, you were given a notice, and it's easy to prove. And that's where the notary stuff comes in. What if I want to say, I told the landlord this fact? So I would write something up, saying that I told Fred the elevator is not working. Then I come in and I have Jose notarize the document that I'm signing. Then that can go into the courtroom, and I've done this with Michael, and it's worked. I go into the courtroom and I say, okay, so-and-so is not here right now, but here is his statement that he wrote, and he signed it, and here's the notarization. Notary is very flexible and can be used very creatively, okay? But now we come to the nightmare. I think this is a loophole in the system. Constructive notice. Let's say Director Mimo owns a piece of land in Lancaster. It's a big parcel, and there's a well on it. I own the parcel of land next to his land, and I decide I'm going to use that water from the well, and I use that for 10 years. Now that is constructive notice, because what I'm saying is he was supposed to see that I'm using his water, but he didn't care because he's got so much money, he's out touring the world, all right? Meanwhile, I'm using his water for 10 years. We go to court because I don't want to stop using it. He found out I'm using the water. And I go to the courtroom and I said, no, Your Honor, I've been using that for 10 years and I've been making repairs on it. That's a biggie. I fixed the well so I could use the water. And the court will probably rule in my favor. A true case that recently happened that they called me about, someone was using part of his land. He's got more land, he's got it all over the place. Part of his land for storage. They actually built a storage shed on his land and were using it, and they used it a long time. Okay, but now comes the really serious part. He was traveling around the world again. okay? Forgot everything and did not pay his taxes, okay? But what did I do? I was a sharp, clever individual. I checked with the county and I saw he was not paying his taxes. And I knew about constructive notice. So I paid his taxes. Immediately, you've lost the game. Once I do that, the tax situation is critical here, okay? So not only is constructive notice the fact that I put a shed on your property and you should have known about it, but I paid the taxes, okay? And that is the end of the game in the courtroom. So if you have land, you've got to inspect it because the court is presuming you know what's going on. Wait a minute, I'm going to forget the thought if you jump all over me now. What happens, watch this, I'm in another case. I'm suing Fred, and I have a lawsuit against Fred, and it's in the courthouse, but I never have it served. I never serve him, but I prepare the lawsuit, and it's registered in LA County Courthouse, okay? But now remember, I'm a devilishly clever human being. So I say, if I notify Fred, he'll fight me in the courtroom and he might win. So what am I going to do? I am not going to serve Fred. Instead, I'm going to perform a constructive notice. I'm going to put an ad in the newspaper and saying that I've sued him. The court, and this is really serious, the court recognizes that as constructive notice. The court is going to say, he should have known. I don't know how the hell he would have known. He was never served. He didn't even know someone was going to sue him. Someone can do that, all right? So I'm in a case now, and let me tell you what I did. I said to Marion, okay, let's go into the LA County Courthouse. Let's see about this notice. Let's see if, let's say I was sued, okay? They find out, yes, there is a lawsuit against you. I said, great. What is the case number? Then I can go into the computer and access the case and see what happened on that case. Because in that site, which I paid $7.50 for to find out, they have to say what is the status of that lawsuit. Whether notices sent out, whether there are ads, what was done. So I went in and found out nothing was done. And I said to Marion, we have to check this every month, at least once a month, to see if there is any action that has been taken that I don't know about. So if you have vacant land, you've got to know what's going on there. What were you going to say?
I was going to say, did you become owner? You put a shack on the storage?
Oh, I got the land.
You?
Yes, I
You
took
paid
the
the
land away
taxes.
from you. The judge says, no, you've used 500 square feet as that shack, and he should have known that you were doing it, and he didn't say anything, and you paid the tax on it. We're gonna give you the land, maybe even, you're gonna give you the shack and the square footage, but maybe you're even gonna get the land. You're gonna say, yes, you took over the land, you can have the land. This guy is traveling around the world. Right? Remember, you're always the bad guy in these things, all right? Okay, now, let's read about constructive notice, because this is really important in this business. Well, Paul, let's say you own a house in Ventura, and you never go there, all right? You don't know what's going on. They added on to the house, they built a second story with no permits. You got a problem. Okay? Okay. Constructive notice is a legal, they call it a legal fiction. It is a fiction that attributes notice of something to a person or entity even though actual notice did not exist. For example, here's the example. A court may allow a person who was unable to be served personally with a notice of a lawsuit to be served by publication in a newspaper. Right? Just what I said a little while ago. Especially when a person has left the state to avoid service. For example, a divorce. The wife and the husband, they leave the state so you can't serve them. Well, then you do a constructive notice. Like when you can't serve the tenant. In a rental, what do? You gotta show that you served the tenant. You do constructive notice, right? You publish it in a newspaper. That's what the attorney's gonna do and charge you a lot of money to do bupkis, very little, okay? The legal advertisement of the summons is an approved newspaper is treated as constructive notice, just as if the summons and petition had been served personally. That's very dangerous, okay? Same thing happens with probates, okay? What does the attorney do? He takes the probate and he puts it in a newspaper like the Journal of Commerce, which the general public does not read, okay? And that is constructive notice. That's all he has to do to get a confirmation of a hearing so he can sell it to his buddy, cheap. Okay? You see the games going on here all the time. In another example, a city may be held to have constructive notice of dangerous icy conditions on a public sidewalk if someone slips and falls. Okay. The court may apply the theory of constructive notice to avoid unjust results and allowing a city to avoid liability for situations in which it has no actual notice. Now you're doing work in that area, right, Ben? All right. A contrary result may lead the city to fail to inspect the conditions of sidewalks. If you can show, look, this sidewalk is 2 feet high, and you're the city, you should have seen that. Don't you go around and look at things? You would win, because that broken sidewalk is considered constructive notice. People can see it. Let's see what it says here. Constructive notice application reinforces the city's duty of care. The city's supposed to take care of these things. Registries exist in county seats for filing records of deeds and liens. By filing, the public is held to have constructive notice of such public records. So let's say the city says, yes, this is a broken sewer pipe. We're going to record a deed or a lien or something along that line, and that's going to be considered constructive notice. Is that something? So it's a hell of a game going on here. So you see, when you're in the courtroom, the judge has a lot of power. The judge is going to decide, what's this constructive notice? Let me read that last line again. Registries exist in county seats for filing records of deeds and liens. By filing, the public is held to have constructive notice of such public records. So, for example, what I was talking about, the lawsuit, when it's filed, that's almost considered constructive notice. Okay, very dangerous situation. So how the hell do you protect yourself? You got to keep checking, you know. How do you know someone hasn't come and put a second trust deed on your property and you don't know anything about it? Okay, what if the courts, and you find out somebody, Jose, put a second trust deed on your house and this guy's a criminal, all right? The court says, but you're supposed to notice. Don't you look? Okay? I'm in another case now where the person is a second trustee, and this person said, I'm supposed to be a first trustee. I says, well, the records in the courthouse show that you are a second trustee. That is constructive notice. He was supposed to look and find out, not 2 years later. What happened when escrow closed? Didn't you see it? Okay? So you see, constructive notice is very dangerous. Actual notice and constructive notice. So I think, Nicole, that's the end of this tape. That would be good for us to think about constructive notice. Okay?